Thank you for joining us for this lunchtime webinar hosted by 5 St Andrews Hill. This afternoon, we will be discussing fighting school exclusions in private and state sectors. This is a developing area of law, and many areas have not yet been challenged in the courts. Institutions may employ vastly different approaches. It is complex as individuals navigate appeals, particularly if they are unsupported, unfamiliar with the forum, and, as one might expect, being engaged in a very emotionally charged dispute. In truth, this is a difficult event for everyone involved. The child, for whom the consequences might be significant, the parents, and also the school and the school's wider community. Unfortunately, it is a process that can be daunting, difficult to navigate, and opaque. In this short session, we hope to demystify the process. We will be exploring the law in place in this sensitive area, and we hope to give some pointers and guidance as to how to best challenge a decision to exclude. We will be looking at proceedings in the state and private sectors and explore how procedures differ. I am Ina Udom, and I will be chairing this discussion. I've been in practice for over 20 years and specialise in regulatory law and complex criminal cases. I act on behalf of registrants and regulators within my disciplinary practice. I have a particular interest in education. I'm a trustee of a multi-academy trust and the member of the management committee of a pupil referral unit. The seminar itself will be presented by Guy Micklewright and Amy Wolfson, who are also barristers here at 5 St Andrews Hill. Guy is a specialist in fitness to practice, disciplinary and regulatory law. Guy regularly acts for students before university disciplinary and fitness to practice panels. Many of those cases concern allegations of serious sexual misconduct by students. He advises parents in private school disputes arising from disciplinary action taken by the school. Before becoming a barrister, Amy undertook a master's in law at Harvard Law School. She is now a barrister with a multidisciplinary practice. She has extensive experience of professional discipline and regulatory cases. In education law, Amy specialises in acting for parents in disputes with private and state schools, and has advised parents facing prosecution under the Education Act 1996. Amy is experienced in resolving education disputes with the minimum conflict to the benefit of all involved. During this seminar, we will be looking firstly at the law and procedure in this area. We will then discuss how to put together a strong case. This will be followed by a discussion around the actual appeal hearing itself. And then we will discuss further routes to challenge should you be unsuccessful in that appeal hearing. At the end of the session, we will have a section for questions and open discussion if we have time. We hope that you find this interesting and thought-provoking, and thank you again for joining us. I'm going to turn now to Amy.
Thank you very much, Ina. So I'm going to introduce and discuss the law and procedure that applies firstly to private schools and then to state schools. I'm also going to cover some law and guidance which applies to both sectors. In terms of terminology, exclusion here, I'm using as a shorthand for permanent exclusion or expulsion. Suspension is often described as a fixed term exclusion. Much of what I say and what Guy says will be relevant to fixed term exclusions or suspensions. But just to keep things simpler, we are going to focus on permanent exclusions. So turning to the first slide, please. Thank you. Looking at private schools, the relationship between parents and a private school is governed by contract law, and that contract may contain and should contain some reference to dispute resolution, possibly even some helpful language about resolving disputes with reference to procedural fairness and natural justice. The important thing, though, is that the contract is not the end of the matter. You also need to look at the school's policies, which will generally be published on the school's website, and also to the law. And my first bullet point at the top there, the Education Independent School Standards Regulations of 2014 is the key piece of public law. The reason I highlight that is because private schools are regulated by the Secretary of State. There are minimum standards that they must comply with, including, importantly, for our purposes, with complaints handling. And those standards must be met in order for the school to maintain their registration with the Secretary of State. So in a private school dispute, as well as looking at the contract and the school's policies, you also want to have an eye to those regulations, and specifically part 7 of those regulations, which deals with complaints handling. Schools will have their own processes, but they need to meet the minimum standards in the regulations. And they include things such as having a complaints policy in writing that is freely available to parents, having clear timescales within that policy, there being a procedure for making an informal complaint, but also recourse to a panel where a parent makes a formal complaint. And there's also minimum standards about the composition and independence of that panel. Generally, schools adopt a 3-stage process, and appeals against decisions to exclude will come in at the stage 3, which is the panel hearing. It can be useful gently to inform the school that you are aware of the regulations and that you appreciate that the school does not have a complaints procedure just out of some kind of kindness. In fact, they're required to have it by law. So the regulations set out the standards at a high level, and then the local policies fill out the detail, which should be consistent with the regulations. And you'll find in the local policies, and you should find, things like the time limit for bringing a complaint and the time limit for resolving a complaint. A key difference between private and state schools in terms of permanent exclusions is the fact that in the private sector, parents do positively have to make a complaint in order to challenge a permanent exclusion. Whereas in state schools, the law requires that governors consider a decision to permanently exclude and whether to reinstate the pupil. The other key difference is the grounds upon which a student can be excluded from a private school. At a private school, that goes beyond just behaviour. It could be that the student is making a lack of progress. It could be the behaviour of the parents, or it could be financial matters such as non-payment of fees. Turning to state schools, firstly, there's no contract law aspect here. There is regulation, and as you might expect, it is a bit more prescriptive. The procedure for challenging a decision to exclude is set out in broad terms in section 51A of the Education Act 2002, and it's filled out in more detail in the School Discipline, Pupil Exclusion and Reviews England Regulations 2012. In short, where the head makes a decision, and it must be the head's decision rather than anybody else's, to exclude a pupil from a school, the first step is for the governing body of the school to consider whether that pupil should be reinstated. That's something that should happen automatically. However, if the parent engages in the process, then that can only be a positive thing. You're likely to have more input into it. The governing body have got the power to direct the head to reinstate the pupil, and the regulations set out the factors which the school must take into account. Also, the parents and the principal and other interested parties should be given a reasonable opportunity to attend the reinstatement meeting, and that parents can bring a representative or a friend. There's further important detail in terms of state schools, in the guidance, which is called Guidance on Suspension and Permanent Exclusion from Maintained Schools, Academies and Pupil Referral Units in England. And there's also other guidance which applies both to state and private schools. And I would highlight the Department for Education guidance on behaviour and also the Department for Education guidance on keeping children safe in education. Other relevant law and guidance is the Equality Act of 2010. That applies to state and private schools. It can be used to bring a freestanding claim, but it can also be used to signal to the school some of the aspects of potential consequences to their actions that may not have been fully considered during the disciplinary process. I had a case where a mixed race student was alleged to have, in quotes, aggressively interrogated a white student, and the context, which seemed to have been lost or never really grasped during the investigation process, was that the white student had been using racist language, and the mixed race student was actually explaining to him, or attempting to explain to him, why that language was unacceptable. And we were able to draw on the Equality Act in making that argument and helping bring that important issue to the fore. In terms of the guidance on exclusion from state schools, as I've said, that does not strictly apply to the private school sector, but it is a useful reference point for two reasons, really. Both because it can illustrate what is achievable or expected in terms of the standards of school investigations and procedures, but also because case law does recognise that it can provide a useful indication of principle for a private school to take into account when considering their contractual power to exclude a student. Thank you, Eni. You're on mute, Eni.
Thank you very much, Amy, for providing that framework so clearly for us. I'm now going to ask Guy. Guy, can you speak to us about putting a strong case together?
Thank you very much, Eni. As you've heard, there are differences between the private school legislative framework and the state school legislative framework, and those have been drawn out by Amy just now. That means that there needs to be a difference of emphasis recognised in planning how you approach building a challenge to a decision to permanently exclude a pupil. And the terminology that's used sometimes, it may be noted, between private schools and state schools does vary somewhat. The old-fashioned term expel does often appear in private schools. However, notwithstanding the difference in emphasis that is required as a result of the differences, many of the issues in practical terms that arise are very similar. And accordingly, to that extent, building a challenge can be approached in a not dissimilar way. The first matter to have regard to is the relationship that exists between the lawyers, the parents, and the child. One issue from the lawyer's perspective is to understand who one's client is, and whether or not it's the pupil, whether or not it's the parents, whether or not it's one parent, or whether or not it is the parents and the child together. It's important, whatever the arrangement, that the relationship is managed carefully right from the outset, and that everybody is acting on the same page. Situations where that may not be possible, and this is why it's important to identify who your client is, can be where, for example, the conduct of one parent is an issue in a private school matter, and that it is the result of that parent's conduct that the pupil is facing expulsion or permanent exclusion, depending on what terminology they use. And it may be in that context that the interests of the pupil and the parent are not entirely aligned. However, for the most part, you will probably find yourself as a lawyer acting on behalf of the parents and the pupil together, and that their interests will coincide. In terms of areas upon which to take instructions, clearly instructions have to be taken in detail on the issue that has immediately led to the decision to permanently exclude. Instructions in these cases tend to be provided on a very urgent basis, and that's due to the tight timeframes that are involved. And that can mean that taking adequate instructions can be very demanding. One issue that you need to have particular regard to is taking detailed instructions on any previous issues that may have manifested themselves. They can include not merely occasions which have resulted in a temporary exclusion or suspension, however long or short that may have been, but also behavioural issues that have been dealt with in a very much more light touch way, and have been issues either of which the parents are entirely unaware, or alternatively have not challenged. This is because schools will often aggregate past instances of poor behaviour and use them to buttress a decision to exclude. The straw that broke the camel's back argument frequently being deployed. And if these haven't been previously challenged and their accuracy is objected to, or the reasonableness of the decision is objected to, then that can cause a potential issue. And in particular, it can cause an issue because it's unlikely that the school is going to have produced evidence to substantiate the allegations in relation to those previous matters. It's unlikely to have formed part of the investigation, if any, that has been carried out by the school. And there may not even be any evidence really available unless those previous matters were the subject of formal investigation and formal sanction. It's important, therefore, to explore those carefully, because it may well put into context the issue which has given rise to the permanent exclusion. It's also important to recognise, when looking at those issues, what time they arose. Because, of course, it's right to note that we're dealing with children, and children develop relatively quickly, depending at what age one's dealing with the child at in the proceedings. And it means that if one's going back even 1 or 2 years in terms of conduct, one would expect that the development of the child since then could well be quite significant, and therefore the weight to be applied on those previous issues may well be far less than the school initially considers it to be. The third matter to explore carefully is whether or not there are any special educational needs or disability issues. And that's to consider not just those which are known, but those which are suspected. If there are any suspected conditions which may have had an impact on the behaviour of the pupil, for example, ADHD or something of that nature, then it may be appropriate to take steps to seek some medical evidence. And indeed, similarly, if a pupil is currently on a route to potential diagnosis, but diagnosis has yet to be confirmed, and no SEN measures have been put in place, then there should already be in existence some potentially useful medical evidence. It may be that one has to go as far as commissioning a report, but the difficulty with that, of course, is that that can take some time to achieve. If special educational needs or disability needs have already been identified, then consideration should be given to whether or not the school is providing adequate support or has failed to give adequate consideration to its impact on the pupil's behaviour as part of the head teacher's decision making. As Amy's already said, both state schools and private schools are bound by the Equality Act 2010, and indeed state schools, the public sector equality duty is also engaged. The fact of the existence and the effect of the Equality Act 2010 is pretty well known in schools, particularly in state schools, because it's referred to so continuously in the guidance. However, as the example Amy's already given well illustrates, it can be significant in certain circumstances to remind the school of their duties under the Act, and particularly when dealing with SEN and disability issues, the very direct impact that those duties can have. Additionally, and for reasons that I'll explain in due course later on in this webinar, it can be worth reminding schools of the alternative remedies that are available in the courts for any breach of the Equality Act. Moving on to the issue of evidence. The standard of evidence, unfortunately, can be hugely variable. While there is some encouragement in the state school guidance to obtain witness statements along with documentary and physical evidence, there's no guidance contained therein about who those statements should be from. There's certainly no expectation that witnesses will attend to give any form of oral evidence, and therefore it is most likely in a disputed case that you'll be faced with multiple hearsay from a teacher tasked with an investigation who has probably just written some notes of the accounts given to them by pupils and then written that up somewhere in the report. Almost certainly you won't have been provided with the original notes that were made, if indeed they still exist. There are a number of flaws that may well have arisen during the course of the investigation. Common ones can be interviewing multiple pupils at the same time, which then of course leads to the most obvious risk of contamination. Additionally, poor questions being asked in the first place, leading to answers that might not otherwise have been provided. Additionally, one may well expect to see something in the report opining as to the standard of the evidence that was given by pupils, by which I mean it's entirely common to see something along the lines of, bearing in mind my knowledge of pupil X, they are generally a truthful individual, and so I think it is likely they are telling the truth. In private school matters, the evidence may well be even more scant, unsupported as their procedure is by specific government guidance. And that can be particularly so with the early stages in the dispute. So one should look carefully at the weaknesses in the evidence, but also look carefully at any weaknesses in the investigation methodology and the investigation report. Obvious questions one might want to ask oneself is, were obvious lines of inquiry not followed? For example, interviewing obvious witnesses. Were inappropriate questions asked? Has there been a failure to properly consider the account of the pupil? And again, follow up on anything in that account that was entirely reasonable and easy to follow up on. Additionally, it's appropriate to remember that it's open to the pupil to obtain and place before a panel their own evidence, not just in relation to the factual allegations and any SEN matters, but also in relation to mitigation. And those are points that should be explored in conference. Moving on to the issue of disclosure, which is tied up, of course, with the issue of evidence. Rarely in private school matters will you find that there's any specific date set for circulation of material in advance of a governor's review. In state schools, there is a specific time frame provided for in the guidance for circulating evidence to parties in advance of a reinstatement meeting, and that is at least 5 days in advance of the meeting. As will be immediately obvious, that can create real problems in preparation, and that is a problem which is compounded by the mandatory requirement in state schools that an exclusion decision must be reviewed within 15 school days of notice being received by the parent. So there's very little time indeed to deal with that evidence once disclosed. It's not generally possible to ask for an adjournment, and that readily explains the reason why so many of these instructions, when they come through, are very much last minute. For this reason, it's important, if possible, to engage in early correspondence with the school and ask, even if it's not in its formal hearing bundle form, for disclosure as soon as is possible. Particularly in circumstances where previous disciplinary matters are being relied upon, there may be some benefit to making a formal subject access request. Now, given the school has got 30 days to comply with the utility of that may well be somewhat limited, but it does at least have the benefit of providing a legal basis upon which to request cited documents that the school does not consider relevant and which you may consider relevant, and that may be particularly applicable, as I say, in respect of past matters where the school relies purely on the fact of the past matter having been the basis for some disciplinary action rather than the underlying evidence relating to it. Private schools raise their own particular issues. Sometimes instructions will arrive at the stage where the head teacher has indicated that an expulsion is likely and has not already made a decision. And that, as Amy's already said, is frequently in order to offer the opportunity to parents for them to withdraw their child. That gives parents invariably very little time to make a decision. Parents are commonly unsure what steps to take at that point. And documents that one should advise them to produce and seek as quickly as possible is firstly a copy of any decision that's been made by the head already to exclude the pupil, or short of that, if no decision has been made, any previous correspondence pertaining to such a potential decision. All other relevant correspondence with the head and any other individual within the school. That may include correspondence relating to any previous matters, but it may also include correspondence about issues such as fees and other matters with the bursar. A copy of the signed contract, not a draft contract, but an actual signed contract and any subsequent amendments. That, as you've already heard, is the basis for the relationship between the school and the parents. And sometimes the terms of the contract do get amended, and you can end up, unfortunately, with the wrong version. Additionally, all current school behavioural, disciplinary, review, appeal and complaint policies should be made available. They tend not to be published on schools' websites, at least not in full, in my experience. And it's important to have them, not only because they will set out the procedure that the school's going to adopt, but also because they form part of the terms of the contract in and of themselves. Sometimes there is the potential for early engagement with the head, either before or even occasionally after a decision has been made to exclude, to see if the concerns involved can be resolved relatively informally. And surprisingly, there are a number of occasions where they can be. And this is well worth exploring with the client. And this is so particularly in circumstances when there hasn't been either A, any previous concerns, or B, if the current matter that's led to expulsion in and of itself isn't particularly serious, and it's been the previous matters that have led to the decision that effectively enough is enough. Unlike in the state sector, having then made a decision to exclude the pupil, there is not a procedure that the private school is then immediately bound into in quite the same way, and at least to the limited extent that it can here, that can, in the right case, be an advantage. Finally, in respect to private schools, it's important when advising clients to understand the culture of the individual private school, which may impact significantly on internal norms and expectations. That's something that should be explored with any client. For example, it may be that school prefects or older pupils are deemed to have some responsibility for a certain amount of discipline over the lower years. And if that is the case, usually they'll be allowed to do so without any training whatsoever. That, unsurprisingly, has the potential to put those pupils in a potentially quite vulnerable position, believing that they are acting within the scope of what the school allows them and expects them to do, only to find themselves following, for example, a complaint made by a parent of a younger pupil, the subject of disciplinary action themselves. If the circumstances are such where some or all of the facts are accepted, and even if on occasion they're not, there may well be significant mileage in the pupil offering a heartfelt apology and a commitment not to repeat the behaviour in future. Clearly, the latter point carries potentially less force if there have been numerous behavioural issues previously, and particularly so if they are of the same nature. And that is why, of course, it's important that you take instructions on those matters and have a plan as to how to deal with them. Finally, proportionality. Recognise that schools can be quite unsophisticated in their approach to evidence and decision making. It's very easy to think of what their decision making should be like with the mindset of a lawyer, and that doesn't necessarily apply in practice. Recognise that the school may decide that there is no mitigation to be had in circumstances where an allegation is denied, for example, something which is plainly conceptually flawed. And that may be exactly the sort of issue where in submissions, either in person, if you're permitted to attend, or alternatively in written submissions advanced by the parents or in their oral submissions, that the conceptual problem with that needs to be identified. Private schools in particular may not take into account that a pupil may be materially prejudiced in a year that they are taking a public examination, or they may have failed to take into account other effects on the child. The ability to secure alternative schooling in a short space of time can be one of those effects. Indeed, sometimes one gets the strong impression that the school, and again, this is unfortunately mainly in private schools, develop at some point during the process tunnel vision and have decided that the pupil in question really does need to be excluded come what may, and that the process really is an unfortunate straitjacket slightly getting in the way. If that happens, you can see that there's a lack of any real weight given to a factor that doesn't support the decision to exclude. And it's important that if that happens, you attempt to tackle it. Proportionality can often be a route through which that sort of problem can be tackled. Thank you very much.
Thank you, Guy, for that. Really helpful, and clearly there are a lot of lines of inquiry and matters that need to be considered when you're building a case. And most importantly, against potentially very tight timeframes, certainly in the state sector, as you've mentioned. So it seems very important to get off to an organised and good start from the outset. We're now going to turn back to Amy. Thank you. And Amy, you're going to speak to us about the appeal hearing itself.
Thank you very much, Eni. Just briefly on some of the points that Guy made, I think I've had pretty much all of those evidential issues come up in cases that I've dealt with. The pupil denies the allegation, therefore there's no mitigation. I've also had when the teacher spoke to the child, the younger child who was complaining of being bullied, and mentioned the name of the older child, the younger child looked scared, and that's evidence. I've also had cases where there's just been a complete failure to engage with the burden of proof. One student says this, another student says another. We prefer the first student. Well, why? Based on what? In what way have you satisfied yourself about the facts of this allegation? So I completely agree and endorse those points that Guy made. Turning to the appeal hearing, so in terms of private schools, this is the panel hearing. In terms of state schools, this would be the reinstatement hearing. Guy's going to address you later about further hearings in terms of state schools. I'm going to make some general observations and comments on the procedure, and then also some practical tips which would apply equally to both settings. So in terms of private schools, the regulations, which I've already taken us to, set out the minimum requirements for the panel hearing. Firstly, that panelists must not have been directly involved in the matters that are the subject of the parent's complaint. That doesn't mean that they can't be involved in the running or governance of the school, simply that they shouldn't be the person who's either investigated the allegation, produced a report on it, or made decisions in respect of it. One panel member, and it could be more than one, must be independent of the management or running of the school. From experience, that's usually somebody involved in the leadership of a similar school or of a school in the area, or somebody who is retired from the education world. And parents are entitled to attend and also be accompanied at a panel hearing. The school policy should set out timescales for filing evidence and arguments in advance of the hearing, but if not, that's something that you should certainly be pushing for, because it's really important in terms of fairness that parents have got all the material that the school is seeking to rely upon well in advance of the hearing. The rules for private schools are silent about legal representation. However, many private schools' policies and or the contracts will have some language in them to the effect that legal representation is not normally appropriate. Firstly, that wording, which I've seen across a couple of schools, doesn't close the door entirely. Secondly, even where the wording does purport to exclude legal representation entirely, there's always scope to argue that it is required on the facts of the specific case. So where a pupil is facing a very serious allegation, perhaps something akin to a serious criminal offence, there's definitely scope to argue that. And there's case law in terms of university cases, which would be on your side. In terms of the hearing itself and the powers of the panel, they've got the powers to make findings and recommendations. Turning to the findings, I would just reiterate what I said about the burden and standard of proof. Depending on the school's policies, the panel may also have the power to direct some further investigation if that is necessary, and often it really isn't. And it's hard to see how that could generally be in the pupil's best interests. The findings and recommendations that the panel can make may extend to directing the pupil's reinstatement, but there's no requirement that a panel have the power to do that. In practice, however, and I think this is the safeguard really, which is the other side of them not having that express power, The safeguard is that the school is likely to be exposed from a contract law perspective if a panel that they've convened finds that they've acted completely unreasonably and made an utterly flawed decision, and the response of the head is to do nothing. Turning to state schools and the reinstatement hearing, you've heard about the strict timescales that the governing board needs to have that meeting within 15 days of being notified of the decision to permanently exclude, and furthermore that they should have been notified by the head without delay of that decision. In terms of the state school rules, there is explicit reference to the parents being represented rather than just being accompanied. It doesn't say either way whether that means legal representation, but also that means that it doesn't exclude it. The powers of the governing body are much clearer at a reinstatement meeting. Quite simply, they have the power to reinstate the pupil at the school. So turning to some practicalities, and I would say that these apply equally to both. Firstly, how can parents prepare if they aren't represented at that hearing? My first observation, and perhaps I would say this because I'm a lawyer, is that I think representation does help. As Eni said in the introduction, these can be emotionally charged matters. Parents will have often been involved in the investigation. Perhaps they've accompanied their child to an interview, for example, or they might know some of the other children involved, or they might know the parents. They'll have also seen the consequences of the proceedings on their child, and that could be a very difficult thing to see. But of course, representation isn't always an option, either because of the rules or simply because of finances. So here are some tips. Firstly, focus on your best points and structure your submissions around them. It's really easy to come up with a whole shopping list of things that have gone wrong and slightly lose sight of the bigger picture in the process. Make it really clear what your position is. Do you accept the factual allegation, but not the decision to permanently exclude? If so, do you agree that there should be some kind of sanction, but simply that it should fall short of permanent exclusion? Do you dispute some or all of the facts? And if so, which? Are you able to say why? What you want to do is reduce the possibility that the panel is simply going to misunderstand your position. If you've already put your position in writing, use that as a basis for your submissions, and that will help you to stay on track. Also, and this is linked to a point that Guy made about evidence, bring in the positive. Give the panel a clear idea of who the child is as a person. This incident doesn't define them, and it doesn't define their history or their relationship with the school, and hopefully you'll be able to bring in material that makes that really clear. Also, show that you respect the school, even though you disagree with this specific decision. If you have a situation where there's two parents attending, who's going to take the lead in addressing the panel? It's much easier to try to agree that in advance rather than be seen to be either disagreeing or talking over each other at a hearing. The other thing to think about is whether the pupil should attend. There's no one answer to this question. It's going to depend on the age of the child, their maturity, also whether there's any special educational needs issues. The time estimate that you have been given may be wildly inaccurate. Do you want your child sitting around for hours on end, either in a meeting or sat outside a meeting room? Would the school facilitate that anyway, or would they say that you need somebody to supervise the child? Finally, and this goes back to the procedural fairness, don't be afraid to ask for more time or even an adjournment if procedural issues arise. What would you say if you found yourself in the position that the school presented a whole load of new material at the start of the hearing? If you're there and you're unrepresented, that's a very good opportunity at which to point out that you're unrepresented and that you would have liked to have been able to take advice, at an earlier stage. So those are some practical points which I think are helpful to bear in mind, particularly where parents are unrepresented during that hearing. Thank you, Eni.
Thank you, Amy. Thank you for those practical pointers, which are so helpful, particularly when it is a difficult situation, as we've said. And if you are unfamiliar, it's really helpful to have just some key points that you can focus on and structure yourself around. Finally, we're going to go to Guy. And Guy, you're going to speak to us about further routes of challenge. This is after you've had the results of the reinstatement hearing in the context of a state school. Thank you.
Thanks, Eni. I'm going to start with state schools and then move on to private schools. And that's because in respect to state schools, there are more options for challenge than or for further challenge than there are with private schools. The main route for challenging a decision not to reinstate is one that is provided for, and it is the ability to apply to the Independent Review Panel, or IRP, to review that decision. That panel does not conduct a complete rehearing. It doesn't rejudge everything on the merits, although that said, there are some oddities with that. But it is supposed to approach it almost like a judicial review and consider whether or not the decision was lawful, whether it was rational, and whether or not it was procedurally fair, so classic public law concepts. Any application for an independent review by the panel must be made within 15 days of notice being given to the parents of the decision not to reinstate. Otherwise, it will be rejected. So once again, not a lot of time to be able to plan the challenge if a further challenge is going to be made. The review, as I say, is carried out on public law principles, and because of that, the power, really the sole power, other than to dismiss the application of the IRP, is to be able to quash the decision not to reinstate, and it will then be effectively remitted back to the governors to carry out a further decision. That decision, of course, may or may not be the same as the original decision. It is, however, though, if the IRP are not satisfied that the decision is sufficiently well flawed such that quashing it is appropriate, to recommend that the matter be reconsidered. Now, the governors can refuse to reconsider because it's only a recommendation, and they don't have to accept the concerns raised in the recommendation. But in reality, the practical effect of a recommendation must surely be sufficient to trigger a proper reconsideration of the original decision not to reinstate. Now, as I say, there's something which is a little bit odd about the procedure, given the specific requirement to apply public law principles, in that the guidance then goes on to say that it expects that the IRP will generally need to hear from those involved in the incident, that witnesses can be called to give oral evidence, and that can even include pupil witnesses, so the pupils consent to do so. Furthermore, fresh evidence can be adduced, even though the school may not introduce fresh reasons for the decision. And that seems to be fresh evidence that can be introduced by either party. If the parents request it, then an SEN expert must be appointed. So it's not the case of there being a discretion. If the parents request it, that individual must be appointed, and it is at the local authority's expense for them to sit on the panel. Their role is simply to provide effectively expert evidence to the panel. They play no part in the decision, and part of their function may include advising on whether or not the school acted fairly and reasonably in its approach to identifying any SEN needs in circumstances where none have been provided. So they can do two things. Firstly, they can advise on the effect of any SEN needs already identified, whether or not within that there are any, but furthermore can go rather further and advise on whether or not the school adopted a proper approach to considering whether there were any in the first place. Representation, legal representation, is permitted at this hearing, as indeed other representation should the parents wish it. And inevitably, the approach to this hearing, when one is deciding how to approach it, has to be one that recognises that it is a hearing that is not considering the issue afresh, albeit with some modification. It is merely reviewing the correctness of the original decision not to reinstate. Likely areas to explore challenge, therefore, can include whether or not the standard of the investigation was so poor and or flawed that it cannot properly be given weight, whether there was a failure to undertake essential procedures, for example, failing to carry out a risk assessment where there's been a sexual abuse allegation, whether the weight apportioned to the evidence is such that the decision is irrational, and additionally, whether or not there's an absence of adequate reasons, although inevitably the threshold for the adequacy of reasons, or rather establishing that there is an inadequacy of reasons, is rather high. Judicial review is a potential remedy that is available. It's available in respect of a decision of the IRP, and it's also available in respect of a subsequent decision of a panel not to reinstate following a review quashing their decision made by the IRP. However, any judicial review inevitably carries significant cost risk. Moreover, by the time the proceedings are concluded, any success may feel like little more than a Pyrrhic victory in any event. The only really tangible benefit I would suggest to the pupil is likely to be their potential for the school record to be improved by obtaining declaratory relief from the court. But even then, there may not be a huge amount of benefit to that, it may be felt, and certainly not sufficient to offset the financial risk that goes along with a judicial review. However, should such a review be sought, then it is important, I would suggest, to consider carefully applying for an anonymity order. In fact, I'd suggest I can think of no circumstances where one would not apply for an anonymity order. Moving on to private schools, the scope for challenge of decisions of private schools is, as you probably gathered from what Amy's been saying, rather limited. Firstly, it currently seems unlikely, looking at the case law, that a judicial review remedy is available at all. And that therefore means that there are only two meaningful routes. The first, which is, if you like, the substantive route that challenges the decision on its sole merits, is to bring proceedings for breach of contract. But that is not inevitably going to result in the pupil returning to the school. It may lead to the recovery of some of the school fees, perhaps as damages, but identifying an actionable breach within the contract may well itself be challenging. The contractual terms themselves are likely to include a reference to natural justice, and if not, the courts do seem prepared to imply a term of fairness into the contract. However, assuming the school has broadly followed its requirements under its own procedures and acted in accordance with its obligations under the Education Independent School Standards Regulations 2014, it seems to me that it is unlikely, on the whole, to be able to successfully challenge the merits of a decision to exclude. One possible tangential challenge, which might bear a little bit more fruit, is a challenge under the Equality Act. And as you've already heard, it's possible to bring proceedings for breach of the Equality Act. There are a number of remedies that are available. Those are remedies that are not going to lead to the decision to exclude being overturned. However, it may just be, in relation to private schools anyway, that it's the sort of thing that can be used as a sort of useful bargaining chip if there is some merit to it. If indeed, as may well not be the case by this stage, there's a continued desire to preserve the relationship with the school and for the pupil to continue to be educated there rather than anywhere else. Thank you very much. Ini.
Thank you for that. Well, we've come to the end of our discussion here, and we just have a few minutes left. I'm wondering if we could just maybe deal with any of the questions that have come in the short period of time we have available. I'm just having a look. Okay, I have one question that reads, and Amy, maybe you could help with this. Is the panel hearing or the governor's review really independent? This seems to be a concern from somebody as to, you know, the forum that they're going to be appearing in front of.
Well, it's not a court. In terms of private schools and state schools, you know, there are personal relationships between the people making the decision and the people reviewing the decision. In terms of private schools, they're often able to draw on some quite eminent people in terms of former governors or former people associated with the school to assist in the decision-making process. So you may well find that you've got a lawyer on the panel, which can usually only help. In terms of both, though, as I say, that there's personal relationships involved, and you can't know whether that's going to count in your favour or not, really. What I would say is that you've got safeguards on both sides. Firstly, in terms of the private school, there is recourse to breach of contract, further routes, as Guy has set out. On the breach of contract point, there are things you can do short of proceeding to full-blown litigation. There's always room for negotiation in these things, and any errors and flaws that you could point to in the process are only going to add ballast to that. In terms of the state schools, there's got to be an eye to the public law aspect of that. So yes, you've got governors involved in considering whether to reinstate, but they will, or they certainly ought to have an eye to the public law aspects of it and fairness, and hopefully that should keep things in check. Sorry, Ini, I think you're on mute.
Sorry, one other question that's just come in, if we can deal with this one as well. We're asked, are any tips for when the school offers in a very short time frame that the parents withdraw the child rather than apply a permanent exclusion? And if you, as a representative, are asked to advise following this option, do we have any thoughts?
I'm happy to take this one, and maybe Guy, if you've got any additional thoughts on it. In my experience,
the unmute button.
Sorry? Oh, have you got it?
No, it's fine. Go ahead.
I was just going to say, in my experience, this happens in pretty much every single private school case. It's often presented as an opportunity to leave with your head held high. It's really important to find out what is actually on offer and potentially to negotiate about it. So does leaving with your head held high actually mean whenever anyone makes an inquiry about you, the school is going to say, well, there was an allegation they did this terrible thing and we were going to permanently exclude them and then they left. Or would it be more ambiguous? Is there scope to agree some wording about what the nature or the circumstances of the student leaving were? Will the head or other people help you to find a new school? And again, on what basis are they going to be approaching new schools to try to help with that? I think it's partly, well, it's, as all of these things are, it's a very personal decision. I've certainly had cases where parents have thought, well, I've got nothing to lose because what you're offering me is, you know, an empty offer. On the other hand, there is a risk that if you don't take the offer and you fight it and then you lose, it's a bit harder to say, well, I could see which way the wind was blowing. It didn't feel fair. And therefore, we just decided to move on rather than fight it out. But yeah, I mean, some parents want to feel like they've fought it all the way. So my tips in terms of practicalities would be find out exactly what is being offered, try to negotiate if there's any scope for negotiation. But ultimately, it's about the parents and the child's appetite for risk in that situation. I don't know if you've got anything to add, Guy.
No, I agree with all of that. The only thing I perhaps would add is whether or not it's the right decision can in part also depend on the time of year and the age of the child. If it's at a time of year when it's going to significantly impact on the child's education, and there's no realistic prospect of quickly getting another school, which is also a workable school for the parents and the child to go to, then it can be highly undesirable indeed to accept that offer, even if it is an offer which comes with a reassurance that no criticism is going to be made. It's been my experience that when that offer's made, some schools will say, for example, if there's a public examination that year, that dependent on the risk, we're prepared to let them stay with the school for the purposes of completing that examination in some sort of amended way that protects other members of the school community. But I think that, for me anyway, would be a key factor. What's the level of prejudice suddenly withdrawing my child from the school is going to have, and is it better all round to continue to fight it at this point? And also perhaps question in one's mind, is there a benefit to fighting it anyway if this is going to so undermine the relationship between the school, the private school, and me and potentially my child, such that actually it may just be better for my child to have a fresh start elsewhere at some point?
Yes, thank you. We're overrunning, so I don't think we've got time for any more questions, I'm afraid. And I'm sorry if there was anyone else who had questions that they wanted to ask. Thank you, Guy and Amy, for your insight and assistance this afternoon. Really, really helpful. At least I hope it's helpful to everyone who's been able to attend. A sensitive, difficult area. Thank you very much to everyone who's attended. And as I say, I hope that you found this helpful. We'll now conclude the seminar. Thank you for attending.